Tuesday, March 24th, 2026. Please note that a copy of the Open Meetings Act is located on the north wall of the Legislative Chamber alongside an automatic external defibrillator. Please stand for the pledge. First order of business is our Douglas County Board of Equalization. Roll call, please.
Commissioner Borgeson, Commissioner Kavanaugh, Commissioner Fahey, Commissioner Friend, Commissioner Morgan, Commissioner Rogers, Mr. Chair.
Here. First, we have items A and B. A being the approval of the minutes of the Board of Equalization meeting held Tuesday, March 10th, 2026. B being a call for a meeting on set Tuesday, March 31st, 2026 as date for hearing on certified assessment corrections reflecting the addition of omitted property to the tax rolls or increased value on property. Do I have a motion and a second for both?
So moved.
Motion by Morgan, second by Rogers for A and B. Questions or comments? Let's vote.
Motion passes 7-0.
Thank you. Next, we have our resolutions, which are items C through K, which we can take in block plus adjournment if desired. Motion by Rogers, second by Morgan. Was there anybody that wanted to comment on resolutions under equalization?
Alan Seibert, 5537 North 140th Street, Omaha, Nebraska, 68164. I have questions regarding 4 of the certified assessment corrections. CAC 2626 is in the Benson market area. It didn't have a land value. The land value of $19,000 for a 5,600 square foot lot equates to $154,000 an acre. How was the land value determined? A vacant lot has not been sold within a mile of this property in the last 3 years. This property sold in October for $289,000. With the land value added, it was just assessed for $215,000. That puts the assessed to sale ratio at 75%, well below the 92% minimum. 2625 is a vacant lot in the Elkhorn market area. It needed a tax district correction. How is a property owner supposed to know if the tax district is correct? The land value was reduced from $70,000 to $59,000 for an 11,000 square foot lot. That equates to $217,000 an acre. A 14,000 square foot lot in the same subdivision sold in October for $70,000. That puts the 26 assessed value at $36,000. The ASR is 52%. 11,000 square foot lot in the same subdivision sold in November for $75,000. But the assessed value for 26 is $36,000. That's the ASR, puts the ASR at 49%. 2603 in the Bennington market area needed an effective age change, which affected the physical depreciation amount. And 2636 in the Elkhorn South market area needed a neighborhood adjustment factor. Why does the market value of an individual residential property need factors for physical depreciation and neighborhood adjustment? Among many other problems, these are indications of the arbitrary and unreasonable nature of the current assessment process. Thank you.
Thank you, Mr. Seibert. Appreciate you coming down today. Other comments or questions on the resolutions under equalization? Commissioner Kavanaugh.
Mr. Seibert.
Yeah.
I want to thank you for this analysis. How long did it take you to put this together?
I started doing research in 2021
Okay.
when I first appealed my process, and I've been
Well, I
putting
think
this
it's on the
together
Capitol of
for this
Lincoln that
meeting
says the
to-
safety of the state is in the watchfulness of the citizens.
Mm-hmm.
I couldn't give them a better example than this. I wonder if Mr. Goodwillie, I know this is probably a case of first impression, could come down and help us with these questions, because it's a good, if nothing else, primer on how we get to these valuations.
No worries. Mike Goodwillie, Douglas County Assessor, Register of Deeds Office. Obviously, this is a little bit short notice, but let me grab a couple of things. First, the tax, all of these things are pretty much clerical corrections that we're making for tax year 25. Information came to our attention that we had something off. At that point in the game, we have to run everything through the board through an approval process. So for example, let me grab one example, the tax district correction. That's nothing the taxpayer really has to do with. What happened was when that parcel was initially set up, somehow it was put in the wrong tax district, which means the wrong tax district is getting some of the tax dollars for that property. So when you discover that, you put it in the right tax district. That may or may not change that taxpayer's property tax liability depending on the consolidated levy rate in its new district. But you can't let it go continue to generate taxes for the wrong district. Let's see, a couple of these others. I think there was a depreciation factor that somehow didn't get added or did get added. For that neighborhood, we were doing some sort of a cost approach analysis, I
Could
think.
I just ask a quick question here? Say in the first one, where Mr. Siebert's observation is assessed to sales ratio are supposed to be 92% to 100%. That's right, isn't it?
It is. But often you'll have sales that outstrip the assessed value. And because we assess once a year or once every couple of years when we reappraise a neighborhood, you can somehow get ratios, sometimes get ratios that are out of whack. When we see more than a few ratios that are out of whack, that's a pretty good signal to reappraise the neighborhood.
So we're not going to be able to get to the bottom of this on the time we have here this morning, but I was wondering if a citizen does this kind of research and devotes this kind of time to three particular cases here, if it would be appropriate maybe if he came and saw you and you looked at these just to make sure that the observation that these are indications of arbitrary and unreasonable nature are not the case. There's some valid.
I think we would be more than happy to take Mr. Seibert's information today and march it back to my appraisal staff and say, all right, can you give me, what's the rest of the story? Is there something that we're missing?
Yeah, I think that'd be a real good thing. I mean, gentlemen put in a lot of time and effort. I commend that. It's the observation of a intelligent citizen. And if you could put aside some time, Mr. Siebert, would you be willing to go up and talk to him?
Absolutely. For your information, though, these are examples. There's hundreds of these.
I understand. And it's like drinking from a fire hose sometimes. But you got three concrete examples. It'd be good to get to the bottom of it. Is that reasonable?
Yes.
Thank you.
Absolutely.
Thank you, sir.
Sure. Add your phone number to that. Let me take that away.
Sure.
Thank you. Let me go to Commissioner Morgan.
I think your idea, Commissioner Kavanaugh, is good. I think, Alan's taken the time to put this in writing, and we ought to make sure that the people, not necessarily Mr. Goodwillie, but his staff, take a look at this and respond. And I know they have a challenging, difficult job for positive, trying to keep track. And there's so many variables because you have some homes that clearly have been totally renovated on 58th and Briggs, and yet you have others that haven't been touched in 50 years. Or on 105th Avenue, I saw one that somebody had mentioned the same thing. They've lived there and haven't done anything. So it makes a big difference, so that makes the job a little difficult. So I think that we should get a copy of the response to this so that we can look at it. Mr. Goodwillie, I said it's not something for you, but it is something for whoever maybe was connected with these properties just to take a look at least because Alan took the time
No, that's what I
to
mean.
at least respond in writing and let us see the result of that and keep this so that we can look at that. And there's not an urgency because I know your people are very busy on some things,
Okay,
if that's not too much to ask.
sure.
Thank you both. Thanks, Alan, for taking the time to do that.
You're welcome.
Thank you. Other questions or comments on resolutions under equalization? If not, we'll vote.
Mr. Chair, did that include adjournment as
Yes,
well?
it did.
Okay,
Yep.
thank you. Oh, I'm sorry, go ahead. Motion passes 7-0.
Thank you. That concludes Board of Equalization. We shall now go into Board of Corrections. Roll call.
Commissioner Borgeson. Commissioner Kavanaugh. Commissioner Fahey. Commissioner Friend. Commissioner Morgan.
Yes.
Commissioner Rogers. Mr. Chair.
Here. First item of business are the approval of the minutes of the Board of Corrections meeting held Tuesday, February 10th, 2026. A motion and a second for approval? So moved. Motion by Morgan, second by Rogers. Please vote.
Motion passes 7-0.
Thank you. Next, we will invite Director Myers for the corrections report.
Good morning, Commissioners.
Morning.
Michael Myers, Director of Corrections for Douglas County. You have before you our report for the month of February. Turning to enclosure number 1, Administrative Services and Personnel. Following the 7th month of the fiscal year, we are $2,680,809 under budget. We do have a couple of significant expenditures regarding projects that are underway. But we are pleased with how we are tracking this fiscal year. $368,934 were spent on overtime costs in February. That is down $130,000 from the previous month. About $780,000 in bond payments were processed by our records division. 5 officers below the rank of sergeant left employment in February, and this includes 1 new officer who did not complete field training. 26 cadets graduated the training academy on February 13th, and as of February 28th, we were 102% staffed among all correctional officer ranks. Enclosure number 2, Community Corrections and Reentry Services. The Sanction Center and Discharge Center placed a total of 8 individuals in community corrections, saving 74 bed days. Work release admitted 26 individuals. House arrest admitted 48. The Reentry Assistance Program, or RAP, admitted 26. Our reentry services and therapeutic communities in the jail, there were 47 individuals admitted to therapeutic community housing units. There are currently 152 individuals on the GED waitlist, and there are 59 active students. 1 individual achieved a GED. 23 individuals were referred to intensive outpatient treatment. 29 individuals received substance use disorder evaluations. Turning to pretrial services, 197 individuals were placed on pretrial release in February. Over the course of the month, a total of 1,554 individuals were supervised on pretrial release. 577 of those individuals participated in 24/7 sobriety. 186 of those individuals were supervised via GPS monitors, saving, in theory, 3,860 jail bed days. That translated into a theoretical savings of $694,800 in detention costs. 15 individuals were known to have missed their court dates. 99.03% of all individuals on pretrial release remained arrest-free. 99.68% of all individuals on pretrial release remained free from violent offenses. Turning to enclosure number 3, compliance. We continue to gather data for all compliance-related activities. Our PREA, or Prison Rape Elimination Act, audit was held in December. We are currently in the process of responding to auditors' requests for certain documentation of certain practices. This process is approaching completion, and we will receive a final report within 180 days of the audit. Our audit of our healthcare services by the National Commission on Correctional Healthcare, or NCCHC, has been scheduled. It will be held May 6th through 8th of 2026. And lastly, our American Correctional Association audit, ACA, will occur the last week of October. Turning to enclosure number 4, population. There were 1,238 admissions. There were 1,200 releases. Our high count was 1,132, and our low count was 1,052. We did have a decrease in our average daily population, down 48 to 1,096. The average length of stay for inmates released in February, the overall average length of stay was 31 days. 50.4% stayed longer than 72 hours. Their average length of stay was 60.3 days. 49.6% of inmates were released within 72 hours, and their average length of stay was 1.4 days. There were 97 custodial sanctioned bed days. The U.S. Marshal population, that's obviously a typo, should say decreased from 71 to 62. The average daily felony pretrial population was 758. That is a decrease of 21. The average daily misdemeanor pretrial population was 117. That's a decrease of 3. Probation violations increased. 21% of our population were between the ages of 18 and 24. 66% of our population were minorities. 15% of our population were female. And 21% of our population were homeless or nearly homeless. Turning to enclosure number 5, medical. There were 1,017 intake screenings. There were 332 health and physical assessments. There were 17 emergent medical care transports. 8 of those were by 911. We had 5 hospital admissions, resulting in 28 total days of hospitalization. There were 35 off-site specialty appointments. There were 138 initial psychiatric assessments and 334 initial mental health assessments. There were 90 individuals placed on suicide precautions. 152 individuals were placed on alcohol and other drug detoxification protocols. There were 7 referrals to the Board of Mental Health approved. The Lincoln Regional wait list has been trending up recently. It is at 33. We currently have 22 individuals at the regional center. And just as a reminder, individuals who are waiting or are at LRC are either there for a competency evaluation or they are there being restored to competency. 3 individuals were administered a total of 5 doses of Narcan or Opvee. I would like to draw your attention to the last page of the actual enclosure of medical. And I included de-identified information regarding some of our most concerning individuals in our custody. I'm just going to go through, read a couple of them for the, just for the the good of the public's knowledge, but refrain from going through the entire list as it is getting lengthy. And if I brought this list with today's data, it's gone from 20-some people to 30-some people on this list. But this is what it was a moment in time last month. As you can see, we have several people who have cancer. We have people who've had strokes. We've had some highly mentally ill individuals. We have an individual who ate his lip because voices told him to. We have people with a variety of heart problems. We have an older individual who is a hoarder and is, I believe, maybe starting to get some impacts of dementia. His house has been condemned, and he continues to go back to his own house and is arrested for trespassing and is brought to jail repeatedly. Ironically, one time law enforcement gave him a ride to his house, and then they subsequently arrested him for being there. So we continue to have just an increasing amount of complex medical concerns. I think that has to do with a variety of things, the continued, mental health crisis across the country, but in our community. We have a lot of people that don't take care or access health care for their physical needs, and that manifests because of their mental illness. And we get those people at our doorstep frequently. So I wanted to make sure that as a board you were aware and give the public a little bit of information regarding the complexity of the medical issues that our medical team and our custody team deal with every day in the jail. Turning to enclosure number 6, security operations and honor guard. Our crisis negotiation team was deployed twice in February. Both were in conjunctions with CERT, our emergency response team, once for a medically mandated shower, and once for an inmate who was refusing to transfer to another housing unit following an altercation. Both of the incidents were resolved without the need for physical force. Our CERT team, our Corrections Emergency Response Team, was deployed 9 times in February. Issues addressed: medically mandated showers, cell extractions, and high-risk medical transport. No staff or inmate injuries were reported in any of these deployments. There were 9 area searches that were conducted. Recovered items included an unknown liquid, hoarded and unmarked medication, and a walking boot that was altered in order to conceal contraband. Our honor guard was utilized 1 time in February. We had 5 staff who were injured during use of force incidents, and 8 were injured during training. I am happy to report that our TAP training is complete. We've gotten everybody through the initial training. There will be annual recertification trainings come up, but the most lengthy and demanding portion of that is done. Enclosure number 7, our staff development, wellness, and retention. There were 92 applications for correctional officer positions. 43 interviews were conducted in preparation for our next academy, which will begin on April 20th. As I mentioned earlier, 26 officers graduated from our academy on February 13th. I also mentioned that TAP has been completed. Initial training has been completed for all staff. We are still working through, there's a plethora of policies that are impacted by our change in moving towards TAP and our strategic inmate management. Those are being knocked out one at a time. 14 staff members utilized the Wellness and Retention Office. 2 staff members were referred to external mental health resources. And we are well underway for planning for our Corrections Week activities, which will be scheduled for the first week of May. I'll make sure that the board is aware of the schedule of activities that week well in advance, so you are always welcome to attend any of those festivities. Other noteworthy items, recently 2 of our staff members have been featured in national corrections industry publications. Heather Robinson, our Educational and Vocational Services Supervisor, wrote an article that was published in American Jails magazine. And William Young, our Wellness and Retention Coordinator, was also featured in a lengthy article in Shift Briefing magazine. The Department of Corrections is fortunate to have many talented staff members, and we are proud of the national recognition that these 2 have brought to Douglas County. And we continue to have operational planning meetings for our mental health edition, which will open late this year. We've covered topics including staffing levels for custody, medical, and mental health staff, training and selection of our staff that will work in that area, even looking at different uniforms, what reentry resources will be present, and starting to develop and plan for the daily routine and programming, as well as a host of security-related topics. And with that, I await your questions.
Thank you, Director Myers. We'll go into discussion here, starting with Commissioner Cavanaugh.
Thanks for this. A couple of things that we touch on every month. So the average daily population is 1,096, down 48, always a good trend. It seems that we've been trending that way for a couple, 3 months now.
At least for the last 2, for sure.
That's good. That's good. Staffing, another kind of good news category, at or above 100%, particularly with the COs, which we've struggled with in the past. It seems that we've turned the corner on that. We have 355 of it authorized, 356, and I think there's a class coming.
There is, next month, there'll be a
Okay.
class coming.
And then the demographics, always troubling, where we have again, minority population of 66% in a county that's overwhelmingly white, with the African-American component leading all other ethnicities, with 47%, but an overall 66% majority minority. I think the African-American component of our population is something like 15%. This, again, not your fault. You take what's coming to you, but it's notable, and we struggle with this on an ongoing basis. It's troubling. A couple of more specific things. One is medical trips. So if we got 1,000+ people there, I mean, obviously there's going to be people that need to see the doctor, the dentist, whatever, and we take them off campus for appointments.
We do for some.
Okay.
We have our own physician.
I
We actually
appreciate it.
have our own
I'm just talking
dentist.
about the off-campus
Yes.
trips.
Yep.
Okay. So it would seem that we could track that. I would imagine that we have daily or almost daily off-campus trips. My question is, do we have a dedicated medical transport unit, same officers doing the same thing every day, or do we pull people off of staffing to do these?
So the answer is yes and no.
Okay, do we have a dedicated medical transport?
We don't call it a dedicated medical transport team, but we oftentimes use our emergency response team, especially if we know that we have somebody that might be a little high risk bringing out into the community, that we will send members of our CERT team who also happen to be on duty that day to make those transports.
Okay, so to drill down on this a little bit, I don't see, in our use of staff, where we would account for this. I don't know if that comes under light duty. I don't see any other category where we would say these people, COs or whatever, aren't working on a mod. They're transporting people, which has to take hours and hours.
It does. So in our staffing analysis, we budget for a couple of people on our waking hour shifts primarily for transports, because we know that they happen
Could we track
regularly.
that so we know the amount of time daily, weekly, monthly, that we're utilizing people?
We track the number of trips. I will see if we can also track like an average length of time that
Yeah,
they're
it'd be
off-site.
interesting to know, how many officers are spending how many hours on this, and if it would justify looking into maybe having a dedicated unit. We'll come back to this.
Other questions or comments on the corrections reports? Commissioner Kavanaugh, do you want a second round?
So if you could, between now and the next time, maybe give us a snapshot of that. And I don't know if we've tracked it going back, but if we haven't, we got a month to do it going forward, just so that we know the occurrence. Like I said, with a population of 1,000 plus, it's probably close to daily. And then the hours. So have them keep track of their hours of trip to the hospital. It usually takes me a couple hours, even if I'm going in for just a checkup or something. Right. And that's getting there, doing it, and getting back. And I presume you have more than one officer transporting.
Correct. We would never do a one-on-one.
Right, okay. If we could look at that, I think it'd warrant maybe a second category on here. I think we talked about this before, where we take officers out for training, for instance, and tracking that as well, so that, we have an idea of, these are necessary services, but they're not the mainline thing that a correction officer does working the mods. Okay. The other question I have is, we have the new mental health unit coming online, and we just had this at the Board of Trustees yesterday for the new mental health unit at 42nd Street. Could you give us an estimate of staffing costs? Those, that new facility, the estimates range up to $1 million plus, just on staffing.
Right.
And I don't know if that's going to be exactly the same, but you're going to have, and maybe you already do, some cost of running that new facility, in addition to your current budget.
Yes. I'm going to have to give me the opportunity to go back, because we did these calculations for the board during the proposal phase of this.
As we always say, there's building a facility, one thing.
There's running it.
There's running a facility, totally different thing. And the second thing is much more expensive over time, usually, than the building.
There are some advantages, some efficiencies we're going to be able to gain with this facility, where we'll be able to operate the existing jail a little more efficiently than what we currently are able to do. And some of the staffing resources that are currently allocated in our existing facility will be able to be repurposed and specialized into the new addition. So it will probably take, to operate it 24/7, upwards of 25 to 30 people, FTEs, to operate that 24/7. However, it's my belief that hopefully close to half of those are already working for the department, and we will be able to just shift their current assignment over to.
And maybe next month you could give us a little closer estimate on that. One final thing, and this is at page 5, I believe. Program fees. What are program fees? We've got a couple of different numbers for program fees.
So most likely they'll use our referencing. You're saying you're on page 5.
Maybe it's page 15.
Yes. So
yeah, it's got program fees
our
of a total of $2,096, and then later on it's got program fees of $23,000 month to date, $40,000 year to date.
So some of our community corrections programs have a cost for the participant associated with them. It's been that way for decades.
So are these real dollars?
These are real dollars that the participants in these programs are paying to the county for the privilege of being in those programs.
Inmates are paying Douglas County.
Correct.
Okay. No, we'll come back to that.
You can finish your final third 2-minute round.
Yes.
For Commissioner Kavanaugh. Yep.
Okay. What are these fees for?
So, for instance, if you are on pretrial release or if you're on house arrest, might be fixed with a GPS monitor. So these would be fees to for the county to be made whole for the cost that we pay. And and just to make sure everybody is aware and the public's aware, we have provisions in all of our programs for indigency. Fees are assessed only when people are actively employed, making money, and can afford to pay those fees.
Okay, so if you can pay it, you pay it. If you can't, you're declared indigent and you're provided with the service or whatever.
That's correct.
Okay, thank you.
Thank you. Other comments or questions on corrections report? If not, we'll go ahead and conclude. Thank you, Director Myers. I'll take a motion to adjourn Board of Corrections. Motion by Morgan, second by Rogers. Please vote.
Motion passes 7-0.
Thank you. We're going to go into Board of Commissioners agenda. Roll call.
Commissioner Borgeson, Commissioner Kavanaugh, Commissioner Fahey, Commissioner Friend, Commissioner Morgan, Commissioner Rogers, Mr. Chair.
Here. First item of business is Section 1, items A and B. A being the approval of the minutes of the Board of Commissioners meeting held Tuesday, March 10th, 2026. And B being the approval of claims submitted for payment process through Tuesday, March 24th, 2026. Do I have a motion and a second for both? Motion by Morgan, second by Rogers. Please vote.
Motion passes 7-0.
Thank you. Next, we have our consent agenda, which are items A through Q. I know Mr. Clerk and possibly legal counsel have a few items that we need to table and then potentially also take separately. So, Mr. Clerk, do you want to start?
Yes, Dan Ash, Douglas County Clerk. All right, quite a few things. So I'll start off with the layovers. We are going to be laying over for 1 week. Items B. B as in boy. C. D as in David, but just numbers 3, 9, and 10. And then item F. So those are the items that are being asked to be laid over 1 week. Some of the other ones are just changes. Did you say F? Item F, yeah. So again, for the layovers, item B as in boy, item C, item D as in David, numbers 3, 9, and 10, and then item F. Some of these other changes, there's only one that hasn't been updated in your document, in your binder, but the website doesn't include some of these updates, so we just wanted to announce them, and I'll let you know which one would be different for you all as well. So on item A, the last sentence of the resolution, we need to add, so basically the last sentence, strike the period, and then add, and authorizes the sheriff to sign the necessary documents to execute said memorandum of understanding. I believe that's in your guys' in the commissioner's binders, but that part would not show up on the website. We'll update these will get updated after the meeting. Items 2, consent agenda item I, 2, and 3. The last sentence of each resolution will have the following language removed, and the chair of the Board of Commissioners is authorized to sign said contract on behalf of Douglas County. The chair doesn't need to sign the contract, so that part is being removed from the last paragraph of those two resolutions. On item I-4, backup link to the online agenda includes a page about web content accessibility guidelines, and that was not intended to be a part of the item. So if someone's looking at that agenda item online, the third page is not relevant to the item. On item O, the link to the backup on the online agenda does not include the pay scale, or there's like a 2-page printout that includes the statutory language of 23-403 and 43-2023. But this other part of that item that would not be updated in the commissioner's binders is in the second paragraph. They're striking some language. They want to strike some language that references the district court and change it so the paragraph just simply says, whereas the pay rate for the bailiffs and administrative assistants of the separate juvenile court of Douglas County will be set at $41.53 per hour. And then item P, it's my last one. The resolution is not currently included with the backup link to the online agenda. So, might be a record for me as a county clerk for how many announcements I've had to make for the consent agenda, but that is everything, and happy to try to answer any questions there might be. Last one was item P. The resolution associated with that should be in the commissioner's binders, but it was not included in the backup to the on the online agenda. Yeah, yep. P is in Paul.
Thank you, Mr. Clerk. Anybody else, anything to add? Or was that cover it? Good? Okay. Mr. Rogers? Okay.
I move to approve the consent agenda with the changes noted in the record by the county clerk.
Is there a second? Second by Morgan.
I do have a question.
Motion by Rogers. We'll start with Commissioner Rogers.
Okay, question A is, item A is somebody here from the sheriff's office to speak on a question I have.
Captain Kovarik, Douglas County Sheriff's Office.
Captain, how you doing?
Fine.
So I'm gonna be very clear. I'm asking this in light of the times. The contract is about body cameras, but I want to ask this to see who has some jurisdiction here. So page 3, under the mission reads, primary mission of the task force is to investigate and arrest as part of joint law enforcement operations persons who have active state and federal warrants for their arrests. Then it goes down on that page and it says, under supervision, the second paragraph, direction and coordination of the VOTF, which is the Violent Offender Task Force, shall be the responsibility of the USMS, United States Marshal Service District Chief Deputy Administrative Matters, which are internal to the participation agent. Yeah, basically, the U.S. Marshals has responsibility, but the administrative matters are to you all. Then on the next page.
Are you on the addendum or which?
No, I'm in the contract.
The contract.
Because I'm setting up, I want to ask this to you. Like I said, I know this is about an addendum to the original contract, but in light of the times, I got a question for you. So then it says on page 2 of 3, second paragraph under personnel. Task force personnel may be required to travel outside of the jurisdiction to which they are normally assigned in furtherance of task force operations. So my question is, if you sign this contract and you're in the U.S. Marshal Service, if the DOJ gives some orders for this Marshal Service to do something regarding immigration, who says no or yes? Are you all obligated to do what this task force does, or do you have an opt-out clause? And I'm strictly asking this in light of the times. I wouldn't have a concern about this now, but I'm curious now if for some reason an agency decides to take you all off the matters of this and use you for something else, do you all have to follow this, or do you have some opt-out where you all don't need to do some agreed upon task in here?
Yes, yes, we have the ability to opt out. We've pulled off deputies for other assignments for conflicts of interest and those types of things in the past.
Okay. So, and I just want to note that, so I'm assuming you all are going to adhere to the strict requirement of the contract and not go outside the order in regards to some things going on. So
Yes,
I'm gonna give you
that's
that
what,
difference.
yes, we will.
All right, thank you.
Thank you. Before continuing our dialogue on consent agenda, could I take without objection from the board the separation of item O? I wanted to actually discuss that one separately as there was various HR and legal concerns on that one. So,
Which one?
O, yeah. If the board's okay with taking that one separately. Yep, okay. So we will proceed with consent agenda minus O, and all the other ones that the clerk mentioned are being laid over. So other comments or concerns or questions? Commissioner Kavanaugh?
Did I just hear you say we're laying over O as well?
No, just taking it separately.
We're taking it separate?
Yeah,
Okay.
we'll still discuss it.
Today?
Yes, correct. All right, Commissioner Friend.
Thank you, Mr. Chair. So it's not that, I don't even know where to begin here. This was a consent agenda, and we have 1, 2, 3, 4, 5, 6, 7 items that we're going to lay over. Here, I guess here's my question, and it might just float out there in the ether. How many of these layover requests are administrative asks by the individuals or the administrations that are seeking resolution approval? So is this that we? Let me give you 2 quick examples. Let's separate O out, but let's talk about P, the reappointment of a person to the Douglas County Housing Authority. That's one. Another one, the Douglas County Community Mental Health Center did Director Driver initiate these asks. Another one could be F, the reallocation of 2025-2026 Visitor Improvement Fund grant award to the Patriotic Productions. Where are we? We have a loaded schedule next week then. I mean, I guess what I'm getting at is, are they just going to be back on consent agenda? Are they going to be out in the open so we can debate all these? And ultimately, why are we doing this? I read all my emails and things are going in different directions, but this is a lot. So I'm just a little, if one of these department heads wants to weigh in, I'd be happy to hear it. We're delaying an awful lot of stuff here, and that's fine, I guess. But what happens next week? So, and Mr. Chair, that's all I have. If somebody wants to comment on this, I'd be happy to hear it.
I'll toss it to Mr. Clerk.
Thank you, Dan Esch, Douglas County Clerk. No, I don't blame Commissioner Friend for feeling the way he has stated. I think Teresa and I and Ellen, I mean, it was like all day yesterday. We're like, oh my gosh, another one, you know? So, I mean, they're all different. Just to be clear, while this is still quite a few layovers, it's not as many as you mentioned. Some of these were just changes I needed to announce. They're still being taken up today. But B as in boy, C, D as in David, items 3, 9, and 10, and item F are the only ones, quote unquote only, are the only ones we're laying over today. Some of the other items you mentioned, we're taking up. I just had to announce that, hey, there were some changes submitted to us that you all should have received, but the public, it's not on the online agenda. And we're still moving forward. We felt comfortable moving forward with them because they're not substantial change. I mean, you know, it's just kind of little things here and there that are different, but they're not substantive changes in so we're moving forward with them. But they're all different. Sometimes I know, like for item C, for example, I mean, it was not Mr. Cassiopo's desire to lay this over a week, but we didn't get everything we needed from MAPPA. And so after consulting with the county attorney's office, we felt it was best just to wait. There's basically some documentation missing that we say with the agenda request form of the resolution that's included, and it's not. And so we wanted to wait until we get that from MAPPA before and we move forward. And I don't think, anyway, it was on that one. I think GIS thought it was included, and then when we did a final review, it wasn't. That's my understanding of that situation. Some of the other ones, I got to be honest, I'm not with the B and D, the items with D and with F. I'm not sure what the reasoning is for the layovers on those. So if Ms. Urich has more, I can definitely turn it over to her.
Yeah, does somebody want to explain F real quick for that layover?
Real quick, sorry, I'm so sorry, mate. I apologize on item C, just to clarify. Mr. Cassiopo did submit everything we needed. It just did not get to the website, but it was a significant portion of the information did not make it to the website. So we felt more comfortable just laying this over 1 week, even though he did submit everything correctly for the agenda, but it just I'm not sure what happened, but it just didn't get on the online agenda, and it was so significant that we determined it was best just to lay it over. So thank you.
Can somebody explain F for the layover reasoning?
So item F is the Visitor Improvement Fund one. And I don't know the reason for that one. I just wanted we were all looking around, and I just wanted to tell everyone item F is the one regarding patriotic productions.
Catherine, were you aware that somebody was going to request that this be laid over?
We were just advised right as the meeting was beginning that one might be laid over, and I think that was just added to Dan's list.
Yeah, I'm looking for a reason, though, from anybody. Yeah.
The Community Services Committee is going to hold a hearing on a variety of grant-related things, but one of them is going to be the process whereby you want to change an existing grant completely from what you were awarded to something different. The committee is going to, going forward, ask that you come in and explain to us why, so we could inform the board whether or not that's a sanctioned activity.
I'm aware that you wanted to table it during discussion, Commissioner Kavanaugh, but to lay it over, I guess, on the front end, I figured there's some kind of technical reason.
Yeah, it'll be back up. The committee hearing hasn't been set, but it will be set in the next.
Yeah, I'm aware. I don't think you heard what I said. I'm aware that during discussion you wanted to table the item, but if we call for a layover up front, it's usually for like a technical reason or some kind of something's not ready to be presented.
Right.
But if everything is ready to be presented, I would prefer that it's left for discussion and then you motion to table it, just so we follow the typical procedures on that. So what I'm hearing is that there was no technical reason to lay it over. It's that.
Well, actually, there is. This completely changes what the original grant was for.
Yeah, I know, but the resolution already captures the substance of that explanation.
Right.
You just want to table it. But at this point, it already was taken off and laid over, so we'll just leave it at that. I'm just saying, in the future, we should just follow typical Robert's rules and table it during discussion. But I don't want to prolong this consent agenda just by the messiness of what is the consent agenda today. We do have a motion on the table for consideration of what is still on the consent agenda, minus the layovers that the clerk called for, and minus O, which will be discussed separately. So other questions or comments on the remaining consent agenda? Commissioner Fahey?
Nope.
Commissioner Borgeson?
Yeah, could I just ask one more question on item A? Is there a current Sheriff's Department task force involved in the immigration issues with the federal government?
No.
There's not one in existence right now. You're not working with them.
No, we have
In those
nobody
matters.
assigned with an ICE task force at all.
I'm sorry?
No, we do not have any personnel assigned to an ICE task force.
Okay, thank you.
Okay.
Other questions or comments on the remaining consent agenda? Board or public? If not, we'll vote on the consent agenda.
Motion passes 7-0.
Thank you. We're going to go to item O. Yesterday and this morning, I had some staff from HR and legal, I guess, have some questions about the matter, and perhaps some staff were surprised that this came up on the consent agenda. So I just wanted to allow time for whatever remaining questions, concerns, comments there might be in regards to this matter. So HR, legal, Patrick, does anybody want to kick off the conversation on any remaining questions?
Teresa, your county attorney's office. It was simply a procedural question more on my part, and I'll leave the financial and some of the others to the other folks. It's normally not something we would see come through without a committee meeting. If there's no, it's my understanding there aren't any job descriptions or a pay plan associated with this particular item. And so I just had a question about it being on consent and should it be in a different place. And so my question was more a procedural one.
Thank you, Teresa. And then Karen, from your perspective, you had some questions.
Hi, Karen Butch, HR Director for Douglas County. Our concern in the HR department is that we report to the board, and that normally when we have a department or an entity within the county come forward and ask for changes in compensation, there's usually some discussion with our office. We want to make sure that there is there's equity throughout the county and our positions, because even though the courts and those employees are overseen by the judges, they are actually Douglas County employees. And so if there's any kind of concerns that are expressed by the employee, then the county, and generally HR and or legal, gets involved in helping to try and resolve those. And those don't happen very often, but they do arise occasionally. And so we just wanted to make sure that we were processing this request for an actual placement of jobs onto a compensation structure that was appropriate and paid them appropriately. And so that was our concern from an HR perspective.
Thank you, Karen. A few more clarification items before we get into discussion with board and public. This one probably is more for the court itself, whoever wants to speak on behalf. The resolution does read that this would take effect on the first pay period after February 27th, 2026. So therefore, it would be under the current fiscal year. What would be the financial implications of this effect? And is that budgeted within the current fiscal year? If not, what kind of over budget are we looking at?
May I approach? Thank you. Good morning, Commissioners. Chad Brown and Raymond Curtis. I serve as a judge and currently the presiding judge of the separate juvenile court for Douglas County. Mr. Curtis is our court administrator, 1717 Harney. May I answer your direct questions? I'm going to defer to Mr. Curtis, who has that financial. And can I just clarify, this is not a step plan. This is a raise to match what the step plan has created. But Mr. Curtis has those financials for you. Go ahead.
Sure. The current rate that the bailiffs and administrative assistants are being paid right now for Douglas County Juvenile Court is $40.90 per hour. The new rate would be $41.53 an hour, which is a difference of 63 cents per hour. That represents $1,310.40 annually per person, so that's $15,724.80 for all 12 employees. For the remaining part of this fiscal year, which is 4 months, would be $5,236.36. We are currently operating $400,000 under budget, so this is well within our budget.
As far as your anticipated, I guess, budget cushion, let's call it, but it wasn't necessarily budgeted, but you expect that you'd have the cushion. Is that correct statement? Okay. I might have a few more questions, but let me jump into some of my colleagues. Commissioner Kavanaugh?
Thanks. The total number, all in, to move to this compensation package per year to Douglas County is what? All in, one number. Annually increase to
$15,724.80.
I'm sorry, I'm having difficulty hearing you.
$15,724.80.
So if we approve that, that's what Douglas County ends up paying in addition to what it's paying now?
Correct.
A year.
Per annum, 15,000, I'm sorry?
$724.80.
And this affects, did you say 12 employees?
Correct.
So, HR, Ms. Bush, if you could for a second. And that's the total ask here. I just want to be clear on that.
Yes.
Okay. While she's coming down, does this mirror exactly what we did compensation-wise for the district court last?
We believe it does, yes.
Very close. Could you come up for 1 second?
Yes,
Thank you.
Commissioner.
In the discussion that we went through for the district court thing, it appeared to me that there had been fairly long process to get to the actual thing that we approved. Is that
Yes.
right?
That's correct.
Okay. And this may have been over the course of a year or more?
It was over a year.
Okay.
It was close to 2.
All right. Similar process involved in this request?
No, and I think now that I've heard what they have to say, I don't think they're asking to create a compensation plan and job descriptions and step structure, which is what they did in the district court. It appears to me from what was just communicated that they are just asking to take the existing bailiffs and place them on the same step, because the bailiffs evidently have all been paid the same over the years. So they're just looking to match the step that the bailiffs will be paid at for the next year. But the difference will be with the district court is upon their hire date with the county, they will actually receive a step increase above where they're at now. So without them moving to a step increase, there's no way to keep the bailiffs paid the same. And so if they just want to move them to the step that all the bailiffs are initially moving to, which I understand may not be until July 1st, but I'm not positive on that. That would be for Sherry Larson to communicate, and I believe she's not in the office this week. But my understanding is that they won't be moving until then, and this request is being made right now in the current fiscal year, so they would be receiving the request before the district court, which is not an issue necessarily. But that seems to be the difference, is that they're just looking to say, all the bailiffs are going to go to this pay rate, and so we just want our bailiffs to go to this pay rate right now. But they won't be able to maintain them being the same without a step plan of some kind. So and I didn't understand that's what they were asking, so that's on me.
So would you be comfortable with taking this step today, or would you want a little more time maybe to reconcile some of these concerns?
I think it would depend on what their goal is. If their goal is just to match the pay rates for now, I think they could proceed with taking action now.
I have 1 or 2 additional.
We'll circle back. Thank you, Commissioner. Commissioner Rogers?
So
So correct me, Ray, if I see this. This is how I see it. This is how I've seen it the last couple of weeks. So, like, there's this understood agreement with the county attorney and the public defender that when things happen in there, you keep them kind of even just for par. That's at least how I understand it. This is in a similar realm. You want to stay up to par with another court.
Correct. Yeah. So historically,
No, but wait,
going
let me finish. So did you all just make the adjustments in the resolution and put it on the agenda?
Yes.
Okay.
Yes.
So this is what I'm gonna recommend, because I'm assuming there's nothing from the board to do that. And Karen, how you said theirs doesn't take effect till next budget year? Till July. Okay.
Actually, the district court one, in the resolution you approved on March 3rd, it went into effect the first pay period after February 27th, which that's the language we were mirroring.
Okay. If you're saying you're fine with it, fine, but what I was going to offer up was, can we move to send this to the HR committee, let you all make it right, because I'm assuming there's no disagreement in the board. Let you all make it right, make it retro, whatever needs to do to get there, but just get it lined up right, so it's all not figured here. And because I'm assuming everybody's on the same deal. If we send it back and let all the language get retro made up right, it'll get done. But I think the spirit is to do it, but I don't know if it's like quite lined up right. Would you be amenable to that?
Yeah, I would be open to that. And could we let Karen quickly clarify on the effectiveness of the pay period for the district court?
Yes, what I can tell you is that originally the proposal that was presented for the district court, which you all approved, had the bailiffs all receiving a pay increase on their hire date anniversary. Sherry contacted me and is interested in making an amendment to have all of the bailiffs receive a pay increase as of July 1st, is I believe the date she's looking to move. So the bailiffs will not, even though the plan went in effect in February, the bailiffs will not actually be receiving their pay increase until July 1. And that is going to be coming before the commission, or before the county board, I believe, probably in either the next meeting or the meeting following that. And so Sherry has been in contact with me. She's been in contact with Teresa Urich. And I did want to clarify one thing. Commissioner Rogers, you said that this is kind of like the county attorney and the public defender. And I just want to make it clear that the county attorney has a separate compensation plan that includes steps. The public defenders does not. So they're treated very differently, even though we look at them as being similar. Their compensation is different. The compensation for the public defender is determined at the will and pleasure of Mr. Riley. And he determines when people get raises and how much they get. You provide him with a pool of funds to compensate, whereas the county attorney's office, their attorneys in several positions are on steps, and they're in the process of working with us to add more positions to their step and compensation plan that we worked with them in coordination to develop, just as we did with the district court.
And Karen, did you want to finish any thoughts?
Yeah. So just my last point on that. Okay, well then let me correct that, because they were in some type of cohesion. They agreed to go outside that piece. For this one,
yeah.
It seems like they just want everybody to be on par. And I'm fine with that. My only thing is, can we send it to committee and just clean it and line it up to make sure everybody's aligned right? That's what I want to suggest. Thank you.
Thank you. Let me go to Commissioner Borgeson.
So Karen, what you just said, the resolution talked about their hiring date. So, and it was approved in February. So those that had a hiring date from that date to date aren't getting a raise?
The bailiffs are being held at bay. There's like 2 or 3 people. They're not quite, I don't believe, quite to their dates yet. But this came as a request, I believe, from the judges in conversations with their bailiffs, I believe. But I'm not 100% positive, and I don't want to speak on Sherry's behalf.
And just back to the juvenile court, this is just an increase, a pay raise.
Yeah.
For their.
For their
step-
bailiffs.
For
Mhm.
their bailiffs to be aligned, if you will, with the others.
Yes, I believe they were placed onto a step.
Right.
And so I believe they're asking for their bailiffs to be placed on that same
On
amount.
that same, yeah, okay.
Yeah.
All right, thanks.
Thank you. Let me take a quick round for a couple items. I agree with Commissioner Rogers. I mean, big picture, I think we have some traction amongst all of us. It's just cleaning up some of the stuff real quick. Though I did want to get our own legal perspective, and Teresa, maybe you haven't spent too much time in the statutes. I definitely have not spent much time in the statutes regarding this matter, but there's a notion of parity, and I don't know if, Teresa, you've taken any time to be able to comment on the statutory regulation placed upon the county in regards to the notion of parity between district court and juvenile court in relation to plaintiffs or staffing. Is there anything on your end that you could comment on that?
Teresa York, County Attorney's Office. There's a specific statute related to the juvenile court compensation for the staff. It's specific to juvenile court, and it talks about that the presiding judge sets the salaries, and it's subject to approval by the county board. And it's in Chapter 43. So that's specific to that court. It doesn't address district court.
In any case, I think that there is a sufficient will to move and row in the same direction. With the knowledge that district court is going to shoot for July 1st, and I think we're hearing, at least from a few commissioners, that there's no real objection to shooting for that parity. I think we can get there. And the difference that you're seeking is not, at least this initial step, is not a big difference, and that's good to know and clarify. But, if we're all in it for the long-term parity of your staff and taking care of your staff in the long term and making sure they don't fall behind the next year and the year after that, then if we do spend just a little bit of time in the HR committee just to clean this all up and create an actual step plan for your staff as well, so that when district court goes up, your staff also kind of similarly goes up, and they're not going to just fall behind in 1, 2, 3 years. I think we can all create that parity for the long term, and everybody steps into that new plan on July 1st is one option if we can all kind of row in that direction. But just wanted to toss it out there.
Sure. Just for clarification, this board did approve the step increase for district court on March 3rd to go into effect the pay period after February 27th. So that has already been done.
Yes, but I think it was clarified that the pay is going to be put on hold so that an amended resolution can come back in 1 or 2 weeks to set a July 1st start date for all of those district court bailiffs, as opposed to their anniversary of work. Yeah, that way they all start on July 1st in district court. But it's up to the willingness of juvenile court to kind of work in that direction, or if you still want to shoot for something today, we're open to your comments as well.
Well, as presiding judge, I would ask that the resolution remain as is today, because you have a past resolution from when we were last here asking for parity, and I don't have anything in writing. I don't have a resolution. I know there's comments that it may be July 1. I can tell you I am more than willing to wait until we go lock and step with the district court. But until you have something in front of you, a resolution that you pass or an amendment, I'm here today in front of you asking to mirror what you've already done for the district court, not in a step plan, only as a raise, and to make it to that pay period that is in the resolution. If we choose to hold it and wait, and it mirrors what's happening with district court, I'm game with that. But I don't have a written resolution from district court or an amendment, I'm sorry, to be clear. That's my fear, is you have something right now that you have passed from your resolution of March, apologize, I'm out of time.
No, you finish your thought, please.
I just want to make sure we're lockstep.
Okay.
That's all I'm asking.
No, just take 30 seconds and you can count this against my second time. Just in the interest of good governance and procedure, I don't think it makes sense to approve this and then go to the HR committee and approve something else that supersedes this. I mean, I think we just do it right the first time, even if it takes 2, 3, 4 weeks. I think between now and July 1st, we all have time to get it right. And so I just don't like, what was that? Possibly, but I just wanted to clarify that thought. And I know that there appears to be, I don't know if tension is the right word, but I think, at least for me, I try to let people prove me wrong and give a certain element of trust and cordiality towards my colleagues. So I would assume that Karen and Sherry are not lying to us in that they are shooting for July 1st. And if they are, we will find out, but I don't think they are. And so we would get that amended resolution within the next week or two, and I think we can all shoot towards July 1st. But that's just my thoughts. I do have like 4 lights. And let me see, I think Commissioner Kavanaugh's been waiting patiently, and then we'll go down.
And Judge, thanks for bringing this back to us. I think you should get the clear impression we're just trying to make it right across the board for everybody. If anybody's ever had, and I have, a law firm where you're compensating staff, you want to be real careful to make sure that everybody is equitably compensated for the same work, or you're going to have problems. So I think that's what we want to reflect here. The idea of the public defender and the county attorney being paid the same is a statutory construct for those offices, not for their staff. And so it's not exactly the same. But the idea that we pay staff in one court the same as staff in the other court makes total sense. They're doing very, very similar work. We're just trying to make sure that if we do this, then we don't have the other side saying, well, wait a minute, you didn't do the same for us. And I think we can all understand that. If I'm having the kids mow the lawn, I better give them all the same compensation for mowing the lawn, or I'm going to have big problems. This is something that I think if we take the time that the chairman recommends, that we can get it the same for everybody and avoid that in the future, and maybe make it so that it does last over time so we don't have to readjust it all the time. But I think we're in agreement with what you're asking for. It's just the devil's in the details here. Give us a little more time and we will get it smoothed out. Is that agreeable?
Can I have just a quick second? I want to make this clear. We are in the very early process of exploring a step plan. So if you're asking if by July 1 I can come back and say the juvenile court, separate juvenile court, is in agreements with a step plan, no. I am simply here in front of you saying I want to raise for my employees. That's all it is. It's well within my budget. It's not going to impact you. We're well below our operating expense. That is all I'm asking for. And in the meantime, I want to work with HR to say, help us build these job descriptions. But I'm hearing that took 2.5 years. I'm hearing the county attorneys took multiple years. I'm trying to keep our staff at the same rate as district court while we explore if a step plan is appropriate for our separate juvenile court. That's all I'm asking for today. And I'm asking for the raise to go in effect today. I want to make sure I hear you correctly. You're saying, Judge, would you budge and say, can you amend it to July 1? Is that correct?
No, it seems like if we do, the raise goes in effect today, then we're out of step with the compensation on the district court side, and we have the same problem from those people that you're expressing. Let's try to make it the same for everybody on this front end, and we'll get to what you're talking about, but everybody gets the same. That's what we want.
Commissioner, the problem is I don't know that it's going to be the same because when I was here 2 weeks ago asking for this,
That's what we need a little bit of time to determine, Judge. We can't do that in the 30 seconds that we have here today.
But this is no different than a raise. The county attorney's office, when they went to a step plan, you didn't stop increasing the public defender's budget and allowing Mr. Riley to dole out.
Apples and oranges, actually, but go ahead. Well, if we have the ability to take a little bit of time, I think we can iron this out. That's all we're asking today.
And I am, with all due respect, commissioners, I am saying this is a raise well within our budget, why it's on consent agenda. This is not a step plan conversion. And we've been in front of you in the past for raises for our employees. And I'll submit on that as my time.
Thank you, Judge. Thank you, Commissioner Kavanaugh. Let me go to the HR Committee Chair next, and then Commissioner Fran. I know you've been waiting patiently as well. But Commissioner Borgeson, as
I'm just curious as if, one, we're kind of messing ourselves up by removing the clause that says the same compensation as the bailiffs of the 4th Judicial District Court, set at $41.53 per hour. If we would have left that in, we would have been fine. I guess I don't have an issue with giving the raise and working with the step plan. Now, the timing, if the district doesn't go into effect until July, then the adjustment is just done in July. That might be different than what the adjustment would be today. But they're just asking, I mean, I'm just kind of repeating what you said because you said it very eloquently. They're here to ask for a raise like many others have of this board to give their employees a raise. We give them the raise, then they've already said they'll work with HR to do a step plan. And so work to do the step plan, and it isn't going to happen by July. It's not. Unless we absolutely pick up districts and put it in to juvenile. That's the only way. And I don't know if that can happen or not. I think we should just move forward with the raise. You're in agreement to work with HR for the step plan. Come July, district will adjust the way they need to adjust. And to me, I think it all washes out fine in the end. So I think we just move forward with the request today, have the HR work with them for a step plan, and bring that back when it's ready.
thank you, Commissioner Fran, and then Rogers.
Thank you, Mr. Chair. I agree with Commissioner Borgeson. The issue, and I don't, at this particular point, I don't have a particular issue at all or a concern about increasing that pay. Here, and again, we're being a little bit redundant, but here's the issue. A step plan is different. We all know that. We're trying to keep pace with a plan that doesn't equate. Every time we do this, we're potentially chasing our tail. The county chases its tail with other governmental subdivisions, including the state, on a consistent basis. We do not, if we can help it, we do not want to chase our tail with internal county pay raises. So we don't want to make a habit of this. I'm with Commissioner Borgeson. I say I don't want to lose bailiffs at the juvenile level. They could leave. They could go to the district court. They could make more money. There's a stopgap here that the judge and Mr. Curtis are promoting. I get that. I'm just saying, all I'm saying is we right now are chasing our tail internally at Douglas County. I do not want that to happen again if we can prevent it. So do I have an answer for it? Yeah, maybe we approve something like this, like Commissioner Borgeson said, get into an HR committee meeting and say, how do we rectify this? So we're not chasing our tail 7 months from now. And I don't even know what the district court's going to think about it. But here's okay, look, it probably shouldn't have been on consent. I agree with that. But more dialogue to come. Mr. Chair, that's all I had at the moment.
Thank you. Let me go to Commissioner Rogers.
So I think I got an answer. Look, I mean, Judge, this is why it can't happen today. Because if she's saying it's going to go into effect in the 1st, if you get yours immediately, then you're set out of whack. They need, but for lack of a better example, I mean, the county attorneys and these guys are the similar scheme. They may not be the same, but the county attorney's office is not in the civil service classification. They are. Your people are. And so,
No.
your people in our civil service?
No.
Okay. Still, if you give yours today, it's going to set this off. And I think if you send it to a committee and work it out, there won't be an imbalance, because if they're getting theirs the first, whatever makeup can be adjusted. Because if you need time to work this through, you can work it in there and you can balance it out. But if theirs doesn't go into effect until the first, and you get yours today, then you're out of whack. And then you're going to have to recalibrate this thing. If you send it to committee, you will get where you need to go, which my interpretation is balance and parity. They just need time to line it up. And that's what I'm saying to some degree. And that is, Karen, you can, if you need to speak, you can say that, then I'm gonna make this motion and then go, because I think the motion gets us there.
If I may, Commissioners, I think there is a way to resolve this issue quite easily. I know that there's some concern about parity between when the bailiffs get their pay raises. So, as I said, the district court is saying they want to hold off until July 1. Judge Brown indicated that he would be open to that, but he doesn't want to miss the opportunity if it happens before then. So what the board could do would be to say that they would set it as the same as the bailiffs in the district court. And if the district court goes before July 1, or they stick to their original date, we'll just make the adjustments. It would all be retroactive. There would be no harm to the employees. So to me, that seems to be the easiest thing to do if we're looking at this in isolation as just a pay raise, because that way we would make sure that there's some parity between the two courts. We won't upset one court over the other court, which I think has kind of already happened to some extent, in that they see their bailiffs as being the same and that there was different treatment. And I think this would resolve that issue, and whatever effective date we make for both. And if it's before July 1st, great. If it's after July 1st or it's on July 1st, great. It just seems that that would be the easiest thing to do. And then if they want to work with the HR committee, as has been suggested, to work on or at least investigate a step plan, so that, as Commissioner Friend says, we're not chasing our tail internally with all the increases that the bailiffs would be getting on steps that their bailiffs wouldn't be getting.
But if how I'm hearing this is, okay, you give it to them today. Sherry and these guys come back with their plan, and it gets approved. Are you saying you're working on another step plan that you're going to come back and actually get changed?
Commissioner, this is not a step plan. This is a raise today. Yeah.
I know
I'm working at exploring if a step plan can be done with our 12, well, sorry, it's 17, including Mr. Curtis's administrative.
Oh, and Judge, I don't want to cut you. Just before I get time. What I'm hearing you say is, you're going to get a raise today. They're going to get a step plan. And like Commissioner Friend said, then if you're going to work on a step plan and you come back, then I feel like we're chasing our tail, instead of letting it all get worked out and come in one package. Thank you.
Thank you. I'll take a quick round and maybe move us towards one potential option, which is essentially what Karen had mentioned, in a little bit of what others have mentioned. So I think that, going back to one of Commissioner Borgson's comments, actually, if we take the original resolution and unstrike the compensation of the bailiffs of the 4th District Court, currently at $41.53, because we are essentially making that parity. And I don't think we have to be shy about that, because that is the point of this thing. And then add, to Karen's point, where it says in the second whereas at the end, currently set at $41.53 per hour, and add something to the tune of to be implemented the same day as district court.
I would, yes.
Okay. Oh, strike the 4th whereas. Okay. Because the 4th whereas says this pay would be effective the first pay period. So, yes. So unstrike the part in the second whereas and just maintain the original resolution language. the compensation of the bailiffs of the 4th District Court, unless there was some legal reason to strike that, but I don't think there was. And then in the fourth whereas, amend it to just say this pay would be effective on the same day as district courts. District courts, what would be the best wording?
Compensation plan.
Compensation plan for bailiffs. Okay.
Tracy, York County Attorney's Office. For the second whereas, I think the reason we were striking the same as the compensation as the bailiffs is this was being recategorized as just a raise today, and they were not linking the two at this time. So I think there is some value to leaving that strike in there. And if I misunderstood what you said, Commissioner, I apologize.
Okay. That's fine as long as we still get there, because the 41.53 per hour is that first step, and that's the point of getting us there to parity. So we'll maintain the strike per legal counsel. In the fourth whereas, we'll just amend it to say effective on the day that district court implements their compensation plan for bailiffs.
And we'll update that in the Douglas County Clerk Danish in the now therefore paragraph. We'll update the language as well regarding the start date.
So I would motion the resolution with the stated amendment. Was that it?
My question, though.
Oh, sorry. Just was there a second for
Yes.
that?
Wait,
Okay.
motion.
Second. Yeah, I went ahead and made it. All right. So I made the motion. We'll do the second from Rogers, and he has a comment.
Last
Yep.
minutes. Okay. So this, I'm just curious. So, okay, Judge, we do this today. You're gonna meet with Sherry and these guys about their next step. And then after that, you said you all, after the day, are working on some step plan.
I want to make sure I heard you. The judges we're going to start, how do I say this? We have started working with Karen already, emailing, saying, where are we at? What information has been discussed with anybody in the juvenile court about a step plan? We have found there's been no discussion, so we're starting at ground zero. We just got the job descriptions used by Douglas County for their bailiffs. Emailed, Karen did it last night. We're behind the scenes working on, does a step plan make sense? The why, and how does it fit, and what descriptions? Brand new, Commissioner. I didn't even know District Court was considering this. So it is brand new. We're exploring.
So my question is, we do this, we make this move today. On the back end, you're gonna make sure this thing works out right, so we're not chasing our tail. That's my. And I'm assuming you're gonna work this through committee to make sure we're not, because that's my point. You're gonna get, we put this in language today, so everything is leveled out. And at some point, the committee is gonna work through to make sure juvenile court and district court are on one accord on this thing for the future.
That, I think, is what I would hope to see, but again, the statute says that the judges get to determine the compensation for the separate juvenile court staff. So if they decide not to go with the step plan, there's probably not anything I can do as the HR director, because they have statutory authority to do that themselves. But I think the idea here today,
I heard the statute say, yeah, they got authority to come, the board still has to approve it. And what I'm saying is,
they have to approve the budget.
And what I'm saying is, I'm fine with doing that when the committee cleans it up and just make sure it comes on the back end. I just want to make sure everything's lined, yeah.
And I'm just saying, I can't guarantee they're going to go with the step plan. So this brings them to parity as of the day that it goes into effect for the district court. After that, they're investigating with us, and they'll have to make a determination on whether they want to go with the step plan and if they even want to have a written compensation plan, which our office highly advises that they do, because there's only a few areas within the county where the managers are state employees. So in this case, the judges are state employees. But some of the employees that report to them are our employees. And as Commissioner Kavanaugh alluded to earlier, if there's some issue on the part of the staff and it's brought forward by the employee, it won't be the judges that will be dealing with it from a legal aspect. It will be the county. And so that's why I'm interested in having some discussions with them. If they decide to move forward without doing what the district court did and they wanted to do it voluntarily, that's fine. like I said, we have a step plan for the county attorney's office, but we don't have one for the public defender's office.
And no, and the only thing I'm saying is that it's the board still has the role where they have to agree to it. And basically what we're saying today is we're gonna do this to make everything right. But I'm saying on the back end, I'm counting on you as the HR director with the HR committee to get this all lined up, because
I'll do my best.
I don't, I don't want it to be out of whack.
I understand, and I don't want to see the separate juvenile court employees fall behind on compensation either, much as Commissioner Friend alluded to, and you have too, Commissioner Rogers. So
Yes, ma'am. Thank you.
I think Judge mentioned he's open to exploring that option.
Can I, on the record, as presiding judge and continuing on, I will work with HR to explore this and work on this plan. Even when my presiding term expires, I'll work with the current presiding or the new presiding. I give you my word, we are going to explore this. It's just, we had no idea.
Yep.
So.
Okay, thank you, Judge. Commissioner Fahey.
Teresa beat me to it.
Okay, very good. There's a motion and a second on the table. Any other comments or questions? Definitely. I will in 1 second. There might be one more comment. Did you have something, Peach? No? Okay. In that case, the motion was to, we kept the strikeout in the second whereas. Oh, no, is to approve with the strikeout and with the amendment to the fourth whereas, effective date, the same day as district court. That's the motion, yep. All right, let's call the question.
Motion passes 7-0.
All right, thank you for being here. Appreciate it. Okay, as a courtesy, I'm going to quickly ask if under Section 7 public hearing, if the representative of Osaki Steakhouse happened to be here so that maybe they don't have to wait as long, or on Zoom. If not, then we'll just proceed with the same agenda structure here. Going back to new business, we had one item, discussion or potential action to consider the transfer of opioid funds to the Department of Corrections for opioid risk mitigation technology, to be presented by Director Myers.
Good morning, Commissioners. Michael Myers, Director of Corrections for Douglas County. We have been looking into a variety of contraband detection and interdiction technologies for some time. And we currently have 2 body scanners which are fast approaching the end of their useful life, and they are actually beyond their maintenance period, where the maintenance of those machines is included with the original purchase price. There's been a lot of advancements in the technology since we purchased those, approaching 6 years ago now, and there's additional technologies that have come online. We are requesting the use of opioid settlement funds to replace those 2 aging body scanners with newer technology and more effective technology, and also to put into place additional screening equipment for staff, visitors, contractors, volunteers, as it only takes one to introduce a dangerous substance into the jail. So with that.
Can you give a summary of costs that you're foreseeing with this?
Yes. So we're looking at 2 body scanners. I believe, we have to put these out for bid, so I'm giving you estimates based upon some research that we've done. But those may be approximately about $175,000 a piece. And then we are also looking at a millimeter wave scanner, which is a little bit more than that, probably closer to the $300,000. That would be what would be used on staff, visitors, volunteers, contractors, et cetera.
Thank you. So on your end, on the upward side, if it came in on the higher end, what would be the grand total?
I believe we can get all this equipment for that $700,000 figure we're requesting, or hopefully a bit less.
Okay. And just as a quick clarification item before we get into discussion, once we can grab Lori's attention, what can you remind the board, as of today, what are the total in opioid funds that can be used under the parameters of that settlement?
Lori Persh, CFO for Douglas County. I'm actually opening the report, wrong report right now, to get that total number. It's more than 700,000, I can tell you that. And I did want to comment that on the agenda request, it says that it's not budgeted, and it's not in the corrections budget, but we did budget for expenditures of up to 700,000 in this fiscal year from that drug forfeiture opioid settlement fund. So it is budgeted. It wouldn't require a lift like a budget supplement
Okay.
to do this.
Yeah, if you could take a second to look at the grand total and let us know.
Yep.
I will jump to Commissioner Kavanaugh. Okay, perfect. Very good. We'll get that while we're waiting for that ground total. Under the legal parameters of the settlements, were we able to review this and there was no concerns on the utilization for this purpose?
Teresa York County Attorney's Office, the very first time I was aware of this was yesterday, and so I have not had any look at that at all.
Okay. Commissioner Borgerson?
What was it?
That's what I was just going to ask. There's an Exhibit E that has to be followed as for what the funds could be used for. And I don't remember off the top of my head, so I think, again, discussion today, but I think we need to have at least a week to make sure that it abides by that Exhibit E so we don't get off with that.
I'll have to do that research myself, Commissioner.
And I have the Exhibit E if you need it.
And I am aware from other agencies that they have used their opioid settlement funds for purposes similar to these.
Can you tell me who those are? Okay.
I can't off the top of my head.
Just find out who they
I
were
will.
and
Yes,
give it
I
to
will.
us.
Yeah.
Okay.
Very good. And Lori?
I just wanted to give the total number of our opioid receipts to date, $2,191,228. So roughly 2.2 million.
Roughly 2.2 million? Okay. And could you remind us, does the settlement have funds still coming in throughout the years, or is that the grand total and the final total?
We have still been getting more receipts still.
Okay.
So I don't know what that total pool eventually will be, but we're still receiving funds.
Okay. So about 2.2 million at the moment.
Mm-hmm.
Very good.
under
So it is listed as a discussion item, so we can just leave it as such and just circle back to it next week if we need time to make sure it passes legal muster and the parameters of the settlement of the opioid funds. But that's up to the board. Other questions or comments? Or do we want to take that week just to make sure? Sounds like such. Okay. Anything else on your end, Dr. Myers?
What was the name of that exhibit? Exhibit E. Okay, thank you.
Very good. All right, we'll take a week and we'll bring it back next week. With that, we'll continue forward here on our agenda. Recognitions and proclamations, Section 5. We do have one. Does Ralph Russell happen to be here by chance? I don't think so, right? Okay. Well, we wanted to recognize the retiring employee, Ralph Russell, who worked for Douglas County Health Center for 29 years. Quite a long time, and a bit of service to the Douglas County residents and citizens. So we want to thank you for that long tenure of 29 years to Mr. Russell. And I'll take a motion for approval. Motion by Borgerson, second by Fahey. We'll vote on that.
Motion passes 7-0.
Thank you. We'll go to public hearings, Section 7. We have item A, a public hearing for Class C license for Kyoto Incorporated, DBA Osaki Steakhouse and Sushi Bar at the address listed on the final agenda under manager application for Kijun Zoo. Do we have any representatives from Osaki? Well, first let me say I shall now open the public hearing for this item. Was there any reps from Osaki here by chance? If not, is there any comments or questions about this item? If none, I will close the public hearing on this item. What is the will of the board? Motion approved by Morgan, second by Rogers. Let's vote.
Motion passes 7-0.
Thank you. We'll move forward on to our committees. Under finance, we have the budget report as presented. We also have our monthly fee report also as presented. We'll go down to Health and Human Services Committee. We have one resolution brought to us by Veteran Services. It is a resolution approving an MOU with Tyler Technologies, replacing the VetraSpec user agreement with Tyler and user license agreement turnkey solutions, extending the VetraSpec SaaS services according to the MOU terms and conditions. I do think Director Elmore is here if there's any comments or questions on this resolution, but first, do I have a motion? Motion by Rogers, second by Friend. Comments or questions on this resolution from board, public, or anybody? If not, let's take a vote.
Motion passes 7-0.
Thank you. Under Human Resources, we had the weekly personnel report from Civil Service as presented. We do have a need for executive session today for the purposes of legal advice, personnel, litigation, and labor negotiation. Anything else? I think that's it. I'll take a motion for executive session. Motion by Morgan, second by Rogers. Let's vote.
Motion passes 7-0.
Thank you. The board will now go into executive session for the purposes of legal advice, personnel, litigation, and labor negotiation.